so this is the regulation panel. You can't see the name of it, but it's called Regulation, Which Side Are You On? And I think just to frame the panel a little bit, and then I'll have all of our esteemed panelists introduce themselves, and I'll introduce myself. I'm Rebecca Rettig. I'm a partner at FisherBroyles. I'm in both the litigation practice as well as the fintech and blockchain group. So my practices cross both sectors, but the title of this panel is Regulation, What Side Are You On? And I think we've passed the point of one side is should we be regulated versus not regulated. I think at this point everyone understands that regulation is coming, but I think there are a number of different ways to look at it and a number of different ways to slice it. So I'll try to have our panelists be as contrarian as possible to each other for the panel. But before we start, I'll have everyone introduce themselves.
Hi, I'm Josh Klayman. I'm a lawyer in the space. I have my own firm called Klayman LLC, and I also have a consulting firm called Inflection Point Blockchain Advisors LLC. I also chair the legal working group of the Wall Street Blockchain Alliance. And should I mention? Okay, all right. I'm co-founder of Diversity in Blockchain, and Rebecca didn't mention this, but she's chair of the New York launch of Diversity in Blockchain.
Hi, I'm Phil Liu. I'm one of the co-founders of Arca. Previously, I've been a practicing securities lawyer in New York, and I'm also qualified in California as well. I've been doing this securities law since 2001. Kind of fell into blockchain when a lot of companies started coming to us asking for opinions on whether their tokens were securities or not, and realized that this whole space needed a little bit more order, and there was a lot of opportunity. So here I am. I'm excited to be here with you.
Hi, I'm Susan Gault-Brown. I'm a partner at Morrison and Foerster. I'm co-chair of the firm's blockchain group and chair of the firm's investment management group. And I used to be an attorney at the SEC in the Division of Investment Management.
Hi guys, my name is Katherine. Currently I'm an independent crypto consultant, but before that I was the director of business development at Messari. So Messari is a New York-based crypto company that does a lot of data and research and a lot of sort of content creation around the information side. Previously I was actually in law school, but obviously decided to join crypto coming out of law school.
My name is Santori. I'm the president and chief legal officer of blockchain.com, previously .info, largest wallet services provider in the world. We have 35 million wallets. I guess for this crowd, probably the most relevant thing that I've done is I was an author of the SAFT project framework. If any of you have bought tokens recently in the United States, well, they probably followed the SAFT framework. Even if you didn't sign a document that actually said SAFT on the top.
So if we go back to pass back down. So we did this panel, a lot of us were on it 6 months ago, and I was 256. So I think what I wanted to address for the group first is what everybody thinks the seminal event or decision in the regulation of crypto is in the last 6 months.
I'm actually the right one to go last, but I'm happy to give sort of the background. What happened, one of the big things that happened recently is the SEC, of course, explained where they think, what tokens they believe are securities and what makes a token not a security. I think the most important thing that's happened in the last 6 months has been what the other countries have said, in particular the Financial Conduct Authority out of the UK rejected the test that the SEC uses, and frankly so have most of the other countries that have looked at this. And I think that's incredibly important. Not because the SEC was wrong, the SEC was not wrong. The SEC was interpreting a completely different set of laws than the rest of the world. And that is an important, I think a very effective microcosm to view all of this. And the blockchain, for example, is a global company. The US is like our 4th largest market. It's important to remember that there's a great wide world out there and regulators who view this completely differently, not just in terms of, golly, what risks are we protecting against, but also what we believe to be something that falls within our ambit. The US has a very broad sense of what is a security. It's not so in the rest of the world, and the FCA's rejection of the decentralization test that the SEC articulated recently is a really good example of that.
I wasn't planning on addressing this, but I agree, and I wanted to point out also like what regulators in Asia are doing. So like the Hong Kong SFC has come out with at least 3 guidances so far, and the Hong Kong SFC, similar to the UK FCA, also do not have the same securities definition as US security law does. And so they are able to sort of come in, instead of saying everything is security, say, hey, there's certain things that actually just fall outside our jurisdictions. So their view was sort of like digital assets could be one of them. And then on the US side, it was, for me, I thought it was interesting when the SEC charged Zachary Coburn in his personal capacity. This guy basically ran a self-proclaimed decentralized exchange. This was the first time that an exchange was charged for being unregistered, and also having someone actually being charged in his personal capacity, which I thought really was, I don't think it's happened so far, at least in the crypto space, so I thought that was pretty interesting from my perspective.
So fairly recently, the SEC staff put out a letter where they basically invited comment on the Advisors Act custody rule with respect to digital assets. And there wasn't anything, the letter didn't necessarily make any pronouncements that were earth-shaking, but I thought there were a few things about the letter that were noteworthy. One, the previous pronouncement by the SEC staff in the custody space was made under the Investment Company Act rather than the Advisors Act. And the invitation from the staff in that context was, please let us know how you're going to comply with the custody rule under the Investment Company Act. Which is kind of, here's the framework of the Custody Act. You have to keep your assets with a qualified custodian, and the assets are subject to audits, and there are other requirements of the rule. But it was kind of within the context of how are you going to comply with that rule. The more recent letter under the Advisors Act is a little broader in its thinking. It's how are you going to comply with the Advisors Act custody rule, but also we might think of rewriting the rule, which I think is a really interesting idea. And the fact that they're inviting comment on that, I think, is something that everybody should take note of, because I think it gives people a chance to say, the current custody rule is written for a certain type of asset and not necessarily digital assets. And so the type of conditions that you might put in place for custody of traditional assets, those might not make sense for digital assets, and in fact, they probably don't. And so I would kind of challenge people to think about, if you were going to put in place a regulatory framework around custody for digital assets, and one that was going to keep up with technology over time, what type of components would you put into that type of rule? So.
From my perspective, our company is really trying to get more institutional type investors into this space, and that colors my lens on what I think is the most important thing. And I think actually the most important thing that happened over the last 6 months happened very recently, which was the framework that they put out for analyzing whether a token is or isn't a security, and the accompanying no action letter. And I think that's important for institutions because they really want more clarity than what's currently out there. And although a lot of people have said that the framework and the no action letter creates a lot of uncertainty in the space, I actually take the opposite view, which is it creates more certainty, which is that pretty much everything that has a profit motive is a securities offering. And we should probably focus on that, and it gets people focusing on complying with the law instead of trying to figure out, is something a security or is it not? If it isn't a security, then what is it governed by? So in that respect, I really think that framework, the no action letter, and also the previous statements on what Bill Hedman said at the SEC about how Bitcoin and Ethereum have become decentralized, have actually created more certainty in the space about what is acceptable and what isn't. So I think that's my opinion of the most significant, I guess, outcome.
Thanks. And so I'm going to build off of what you said, Phil, and I think in sort of a way, Susan as well. I mean, if I think back to 6 months ago when we were here, we were kind of talking about, the death knell of the so-called utility token to an extent, greater or lesser extent, right? But I think what we've been seeing in the past few weeks and the past few months is at a bunch of different levels, people focusing on preserving that part of the space. So whether it is at the state level with Wyoming and Colorado, having a consumptive token, open blockchain token pursuant to House Bill 70, or the release or the introduction last night, actually the reintroduction of the Token Taxonomy Act by Representative Davidson, and the introduction of the Digital Taxonomy Act by Representative Soto. I think people are really, whether you agree with what the language in the statutes are, I think people are really trying to preserve some wiggle room and trying to get clarity with the idea that they don't want to have business flowing overseas and away from the U.S. Now, that being said, and nothing on this panel is legal advice or investment advice, by the way, but that being said, the introduction of these bills, the framework that was announced, the no action letter, I don't think that immediately is likely to change many lawyers' guidance that they might give with respect to a particular token sale. Certainly in the case of the bills that were introduced last night, those wouldn't be passed for quite some time in any event. But I do think that it's fascinating to see so many different levels, all focusing. You've got the SEC kind of, in my view, clarifying that when they talked about decentralization, in some ways they're focusing not just on decentralization for a good in and of itself, but actually focusing on the third and fourth prong, or the third prong if you're in the SEC, of the Howey test. So, the Howey test is an investment of money in a common enterprise with a reasonable expectation of profit based solely or primarily on the managerial or entrepreneurial efforts of others. So this decentralization question, which I think the framework that you mentioned really points out, is this focus on reasonable expectation of profit and efforts of others. I also will say one thing about the no action letter. One thing I think is really interesting about it is it was a centralized company, right? So I do think that is, whether you may say, well, the tokens weren't able to trade, outside of that system, it was a centralized company. It wasn't a decentralized company.
And I just wanted to, even though I'm the moderator, I really did want to weigh in on the what I thought was one of the most interesting things to happen in crypto regulation in the last 6 months, which is the Kick Wells response, where a lot of companies, smaller companies, have been coming forward and just complying with SEC enforcement actions, and the SEC was putting out fines and putting out settlement orders. But Kick really came back and said, you're exceeding the scope of your authority by trying to prosecute us. We're going to explain the way our platform works to you, and here's how we're going to advocate for ourselves within the space. We've been extremely compliant, and I think the takeaway from there is to really be thoughtful about how you're operating the space, especially if you're compliant, and if you've really done everything possible and given it a lot of thought. I think working to advocate for players in the space, especially given the innovation of this asset class, and to build on Susan's point to say, traditional rules don't always apply perfectly, and we really need to do this for ourselves. But to take it out of the securities context for a second and try to focus on also that we're talking about investors here and institutional investors, I was going to ask you, Katherine, are concepts like fair launch projects and generalized mining possibilities for investors these days? And if so, what type of regulation do people have to think about in that regard?
Okay, so one thing that I both love and hate about working in crypto is that everything moves super fast and everyone's very creative, and it's really exciting. But on the other hand, what I hate is every time you feel like you've caught up, you're actually behind again. So with that being said, the question that Rebecca asked me was, are investors, is it suitable for investors to think about things around like fair launch projects and also generalized mining? So let me just break these two down. for those of you who feel like you're behind again. So the fair launch project is really a reaction to the way a lot of token sales have been done in the past year or two, which is that a lot of token sales are, sold, pre-sold, actually, so before network launch, they're pre-sold at a huge discount to investors. Or, there's some sort of founder rewards, which is basically if you founded it or you really contributed to the creation of it, that you get a percentage of block rewards or something like that, right? So these are, I think, sort of unfair if you think about it, like compared to Bitcoin, right? Because Bitcoin was, no one else can get their hands on it before network launch. Everyone has to go through the same mining process. So the Fair Launch project is sort of a reaction to the way the token sales have evolved to. And a high-profile project was launched earlier this year. It's called Grin. So Grin really took a lot of the same concepts from Bitcoin, which is that you can't as an investor, you can't go and buy these before this is launched at a discount. You just have to go and mine it like everyone else. However, the issue is, people all think that, this is going to be the next Bitcoin. So what has ended up happening was a lot of investors, and there's been reports, and I don't know if this is substantiated, but this was sort of it seems like everyone inside the crypto circle knows this, is that investors prior to Grin's network launch have put in maybe 100 million in SPVs to mine them. Now, why is that a bad thing? Is because you have turned essentially these people who probably would have been buyers into sellers, and when you screw up the supply and demand equilibrium like that, then that really sort of screws over the investors who maybe put in this money thinking that they were going to generate all the supply, and then everyone would just buy it up, right? So that, I think, sure, I think investors, if you wanted to put it in an SPV and invest in that, you should do that. But I think some of the really clear risks are, you got to think about the demand side, right? You can't just assume that, oh, well, this is just going to be like Bitcoin, everyone's going to want it, because that really disadvantages you. And you also, as an investor, have to think about, well, what is my SPV investing in, right? So that's the fair launch thing. And then on to generalized mining, which is also sort of the hot topic of the day. So whether you hear generalized mining or you hear staking as a service, these are all really talking about the same thing, which is that you as an investor, you sort of have an expectation through someone else providing a goods or service that you'll get this sort of increased proportional share of a network as it grows, right? All things being equal. And it sounds all good and dandy, right? You're an investor, you buy all these tokens need to get put to work. However, it's a full-time job. Maybe you can't run a node. You need someone else to do it. You give it to someone else, they run it for you, and they split, whatever. They'll give you some rate back. And it sounds fine, but there are some serious questions that both an investor and also, I hope you're working with a lawyer in doing this, you really need to ask these service providers, right? For example, what happens if I give you my tokens and you run the node and there's a downtime? What happens then? And my tokens get slashed? Do I have any sort of reimbursement process? What happens to that? Or you look at even the service provider, right? They want to run nodes. Well, are your nodes geographically distributed? If one place goes down because, an earthquake, are there other ways to recover that? I mean, so these are just some questions that you really need to think about.
Sorry, that's my way to say it. So I'm done.
So, just so we're not passing the mic back and forth, I'll just speak loudly. So on to go to this contrary position, there are these new ways to invest, but Margaret, you talked about sort of continuing to use the staff as a way to invest in tokens. Briefly, so we don't have to turn off.
Yeah. Who here is service? Who's working? Okay, who here is service staff? Okay, I apologize. Back in 2017, just in a shower. Just kidding. That's what they teach you in law school. Fill the room with your wisdom. So, back in 2017, ICOs were, everybody was doing an ICO. There were hundreds of ICOs in 2017. ICOs are pre-functional sales of utility vehicles. In November, Protocol Labs, I was at the time in a law firm called there, and Protocol Labs and I co-authored a paper called the SAFT Project White Paper. The SAFT Project was a reaction to this frenzy of ICOs. Frankly, we looked at those, and my partners and I, and Protocol Labs as well. And Protocol Labs, of course, responsible for cloud deployment.
said, those are all probably illegal and you shouldn't be doing it. And we published it in a 21-page white paper that it essentially said that these things are illegal. Don't do them in the United States. The rest of the world, fine. Selling tokenized security, fine. But if it's a utility token, you're out there promising all of this functionality and asking for people's money in exchange for that functionality, telling those people you're going to exercise your technical and managerial expertise to develop that functionality. What you're doing is selling a security. In the United States, you shouldn't do that to the public. You should follow the security. So if you want to sell it to the public, you've got Reg A, Reg CF, that sort of thing. But by and large, you can use Reg D, right? You can sell it to accredited investors, and that's what we said you should do. It was an impactful thing. A month later, there were no ICOs in the United States. Full stop. It just stopped. What happened? Well, people started using the SAFT framework. Unfortunately, people started using the sample SAFT that we included in the back of that document, which we said, please don't use this, but work from it. Anyway, fast forward to today, people have asked already in the period, well, what does functional mean? What does functionality mean? You're telling don't sell this token until it's functional. Where's that line? Aren't you just kicking the can down the road? Aren't you saying, oh, there's an answer out there, but it's an empty bucket, and the future will fill it? And so we actually suggested in the SAFT white paper, we said, look, this is the functionality. When the network works, the token can be put to its intended purpose. When you, as the issuer or related party, have delivered on the promises you made to induce people to purchase that token, well, it's probably functional. And you probably sell it. And that expectation of profits from the efforts of others probably is there. And people said, okay, well, maybe that works, maybe it doesn't. There were some papers written that said, Marco, you're completely full of crap. None of that makes any sense. There were a lot of supportive papers written saying, actually, that does make a lot of sense, but it launched a great conversation, not just in the US, but also in the hotbeds like Zoom and Singapore. What happened? Well, a year later, we got the 1-2 punch of Director Bill Hinman's explanation of his decentralized test. And then just last week, the sort of more formalistic codification of that, which was the guidance that we got. And what did the guidance say? Don't sell a token before it's functional. It's probably functional when when the sellers, when their efforts no longer dominate the price movement of the token. So if the price doesn't rise up and down based on the efforts, the price doesn't move up and down based on the efforts of the issuer anymore. It basically took what we said in the white paper and said, yeah, most of that's right, but we also got a lot wrong. And it explains some other things, that some additional elements that an issuer should satisfy before they sell the token to the public. I don't have a battery to die.
I'm going to find Kate, so.
Keep me honest. So, what's the upshot? What's the upshot today? Well, there's a really good reason why people were using so many SAFTs. There's a really good reason why people should continue to use not necessarily SAFTs, but at least the SAFT framework in the United States. That said, it's a great big world now. You don't have to do business in the United States. You can do it, well, in a lot of other places too, where you don't have to use the SAFT framework. But anyway, I'm happy to talk about SAFT stuff and other lawyerly stuff. And unlike some people on the panel, you don't have to pay.
Susan, with respect to, you'd raised the Advisors Act before, and I wanted to ask what you thought the import of Anderson Horowitz filing to be a registered investment advisor, no longer a VC fund, was in terms of investing in crypto in the space.
Yeah, so with respect to Andreessen registering as an advisor, the custody letter that I mentioned before, actually, if you look at it, raises a bunch of issues in their questions that are supposedly about the custody rule that are actually basic questions about the Advisors Act that are not about the custody rule. For example, they ask, how does the advisor determine its assets under management for purposes of determining whether it can register as an advisor? And it also asks, how do you determine when your digital assets are securities such that you would need to register as an advisor, which I think goes directly to some of the questions probably Andreessen maybe had to struggle with in terms of determining with respect to whether it was investing in digital assets or not. Were these things securities? If they were securities for purposes of the venture capital fund advisor exception, were they equity securities? And that's something that venture capital fund advisors have to struggle with because it's not necessarily clear that digital assets are equity securities and therefore are assets that a venture capital fund advisor can comfortably invest in an unlimited way. So as a result, you see an entity like Andreessen switching their registration to a full-blown advisor registration and therefore getting rid of any limitations with respect to, or potentially, given this custody letter, it's kind of interesting because you see the staff kind of wrestling with, are these assets securities, taking potentially the opposite viewpoint that you see in the framework and the turnkey no action letter, which is not when is a digital asset not a security, but when is a digital asset a security, such that an entity can register as an advisor. So I think it raises a lot of issues.
Great. So Phil, in terms of being at an institution, and this isn't legal advice or investment advice, but what types of regulation are institutional investors most focused on when they're considering investments in the space, whether it's securities, commodities, things like that?
I thought I had a different question, but I'm happy to answer that one.
Okay.
I think from an institutional standpoint, they really want clarity and certainty. They want to make sure that whatever investment they're making is pretty clear on the laws. And I think that's why there's been such a reticence of big institutions coming into this space, because they don't know what they're investing in. They're subject to their restrictions on their constitutive documents that don't permit them to invest in, let's say, non-public securities. That's why the ETF proposals are out there. Like, why have an ETF on Bitcoin? So I think we're heading down towards that point where there's sufficient regulatory clarity. And you don't have ICOs now just launching on white paper and a dream, taking a lot of money, and then kind of just petering out because it was never really a great idea to begin with. That type of stuff really scares a lot of institutions, and I'm glad we're getting away from that, and there are some regulations. I just want to add, though, that I think now really is an appropriate time for people to be dipping their toes into this space. Arca, the Arca team went and talked to a very large institutional manager out in Baltimore yesterday. They were getting into this space. Eventually, it's still early days, but we're now in a crypto winter, and like housing, you make your money when you buy your house, not when you sell it, really. And I think that this is a time where a lot of the scammers and the charlatans have kind of petered out in this industry, and more legitimate players are coming in. We have more regulatory clarity on a lot of things. And even if we don't have regulatory clarity on when a utility token becomes a utility token, at least we know that there is that exists, and that there is a path to to do a project if you're trying to raise money, or to invest in a project that is not going to be basically non-compliant with various laws.
And then we'll ask one last question. We'll take questions from the group. But Josh, do you think that the way regulation, and I'm using that word broadly, is developing in the United States is forcing people to look at investments outside the U.S. With respect to digital assets or blockchain/crypto companies?
So while I answer that, I also just want to say something just really quickly about crypto winter. I feel like we're in April now, right? So I would like to think that we've planted seeds with all this legislation and these, guidance, and that we're going to see flowering soon. and will be in crypto spring. Just putting that out there. Okay, so in terms of the evolving regulation, what impact do I think that's having? Well, I think a lot of people think, okay, within the U.S., the SEC has been clear that in nearly every case, an initial sale of digital tokens is going to be a sale of securities, right? So some people say, well, wait, this is going to cause projects to move overseas. But I think it's important to remember that no matter where in the world you launch a token sale from, or no matter where in the world you have a token-related project, if you have U.S. persons as purchasers, or if they're material to your business and you need them to be, interacting with you, you're going to have to worry about U.S. laws. And so I do think that while people may, even U.S. persons, you may say, well, I'm going to invest in overseas projects, right? Well, you're still a U.S. person. They still need to worry about you, right? And so I do think, though, that at a broader level, for those who are not U.S. persons, and for those projects who are based outside of the U.S., where there are not, U.S. persons principally involved, and where they don't have to involve the U.S., I think in many cases they try as hard as they can not to, right? And often they seek advice from counsel for how they can best try to exclude U.S. persons, as the term is broadly defined in the securities laws, not just U.S. citizens. So I do think that there is an impact. As Marco noted earlier, many jurisdictions, the UK, Switzerland, others around the world have taken different approaches. And I certainly am not criticizing U.S. regulators at all, because as Marco noted, they have the laws that they have. They're interpreting the laws that exist. But I do think that there is an impact. Now, interestingly, both Wyoming and the federal legislators from yesterday, they have said that it's very important to them to try and keep business within the U.S. So I guess we'll see what develops.
Are there any questions that anyone wants to pose? Yep, go ahead.
Hi, my name's Evan. My question is kind of following up on what you just mentioned, John, specifically about the tension between kind of state level legislative solutions and some of the federal level stuff that we're talking about with the introduction of the token taxonomy. So I guess it's kind of an open question to the panel, but how do you guys think about the tension there where the resolution comes through? And obviously there's puts and takes between the speed of the federal kind of solution versus kind of the more peaceful solutions.
So it's interesting that you say that, and I'll pass the mic, of course. But one of the things that has really been highly criticized, or criticized somewhat, I'll say, to dial that back, about the Token Taxonomy Act is in fact the preemption provision and it preempting state law. Now, many believe that that's to target New York, to help folks out around here. But for folks in Wyoming, what I've been hearing as well, this is going to have an impact on stuff that we passed. So I do think it is a tension. I mean, certainly to the extent that something is a security, U.S. federal securities laws would, but states can still provide additional protection for citizens. So I think it is an interesting case. I will just say this before zipping it. Many point to the idea of states being the living laboratories of democracy or, of the law. And that, it's really been interesting to see what states have been putting forward and query whether that may have had any influence in, what the SEC has done. I certainly believe it had an influence on the Token Taxonomy Act.
I'll just add that even though federal law preempts state law, there are certain areas where state law is very relevant. In particular, with something that maybe lawyers only know about, but it's direct participation programs. And if we're actually going to digitize real securities, there are state law implications like that may affect like things like direct participation programs where you actually have to get state approval. So. Having said that, I do think that, while noble what Wyoming is doing, unless there is more broader acceptance and in larger states like California, New York, Texas, and Florida, it's really kind of limiting, because the whole point of these tokens is that they're broadly distributed, and if we're only talking about certain states, it's really at this point a concept and a theory rather than something practical.
We're slightly out of time, but if somebody wants to answer quickly or have any closing remarks, we can do that very quickly. Okay. We were on both sides of it, but I wanted to thank all of our panelists, and thanks Dave for putting on this great conference and for inviting all of us to be here today.
Thank you.